Hi, this is attorney Ashleigh Rambo with Atlanta Divorce Law Group. I do a series of monthly webinars on the divorce process and what you can expect. This month is Child Custody Bootcamp. I hope you find it both educational and informative.
We'll go ahead and get started. Tonight's webinar is on Child Custody Bootcamp. I always ask people to just hold until the end for any questions, and I'll happy to do a Q&A after we've gone through all the slides. A little bit about us and me in general. I'm with Atlanta Divorce Law Group. I am an attorney that has been doing this for over 15 years now. My undergrad comes from political science at the University of Florida, and then my Juris Doctorate is from the University of Baltimore. I've got over 15 years family law experience. I'm admitted to the State Bar of Georgia, the Court of Appeals, the Supreme Court of Georgia, the Supreme Court of Florida, and I'm a certified guardian ad litem in both the states of Florida and Georgia. So Atlanta Divorce Law Group, our mission is to eradicate the stigma of divorce and to promote healthy family structures. We want people to move on into their next phase of life feeling like it's a fresh start and it's a new beginning, not feeling defeated and beaten down the way that a lot of divorces and custody battles can put you through. And so our goal is to make sure that our clients have all of the tools necessary in order to get to their happily ever after divorce, their empowerment, and their own self-discovery. Tonight's webinar is going to be about the Child Custody Bootcamp, and our goal is to kind of go over knowledge on how to make decisions in terms of obtaining the results that you want to see in a child custody case, and really talk about what's in the best interest of your children. The standard that we use in Georgia is the best interest of the child, and that's what we're really going to be focusing on. And we're going to do this by starting with correct terms. A lot of times we use outdated terminology when it comes to custody issues, and this can inadvertently cause more turmoil in a case than you even intend to do, because using outdated terminology can make a parent feel somehow lesser or diminished because you're calling it visitation instead of parenting time, for example. We're going to do education about the factors affecting custody and what it is that the courts look at when they're determining custody. We're going to do really reasonable expectations when it comes to the court system and what a custody case looks like. And then we're just going to kind of do a review of specific tips to kind of help with the custody case. Okay. So starting with terms you should know. Custody is the overarching word that we use for kids. Like, it's just a legal word for kids. And custody has two subparts to it, as you can see on this slide. You've got legal custody and physical custody. So physical custody is just where your children are. When they're with you, you have physical custody. When they're with your spouse, they have physical custody. We no longer use terms like visitation. We use parenting time. We use primary parent and secondary parent. And really all that means is one parent may have one more day a month than the other parent to determine primary and secondary. It's not the best terminology, but it's what we have at this point in terms of describing physical custody. And then the other option would be joint physical custody, which is a true 50-50. That means that you take 356 days a year and you have right down the middle. That's physical custody. The other side to it is legal custody. Legal custody has two options available to it. There's joint legal custody and there's sole legal custody. Sole legal custody is very rare and it's hard to obtain. If you're talking about a case that's sole legal custody, I typically equate it to, are we talking about a case where DFACS is involved? Sole custody is going to basically, like, in practice, even if not on paper, terminate the rights of one parent. And the courts are very reticent to do that unless there is extreme circumstances requiring it. So 99% of the cases out there, especially in a domestic case, are going to be joint legal custody. And what joint legal custody is it is parents are on equal footing and they have to have discussions regarding their children. They have to have a good faith effort in terms of what is best for their kids, and they have to talk about it. Absent an agreement on those issues, somebody is going to have final say. Somebody is going to be tiebreaker. There are 4 issues that we have tiebreaker on, and the court says you can split those 4 issues however you want. One parent can take all 4 of those issues. You can do 2 and 2. You can do 3 and 1. It's just somebody has to have a tiebreaker when it comes to 4 legal subsections that we'll get into in a little bit. There are really 3 factors that can impact child custody outcomes. One of them is actually the number of women that are reentering the workforce. With women having to go back to work, it does affect what custody looks like and what parenting time looks like. Traditional social norms regarding parenting plays a very large role in terms of parenting outcomes. And there's also a lot of academic research that goes into that. What I will say about academic research, because I don't really go into that in terms of this presentation, is if you have an idea of what it is that you are looking to accomplish in terms of your parenting time, whether it's 50-50 or primary, secondary, I challenge you to look into the academic research that says the opposite, instead of looking at the academic research that supports your case. Give yourself the ability to challenge what it is and make sure that it's what is best for your children, instead of going into an echo chamber. The academic research that would be used possibly in a trial, your attorney is already going to have available to make your argument for you. So challenge yourself to making sure that your position is really what is best for you, what is best for your family, what is best for your children. Number of women in the workforce. How the increase in mothers going into the workforce does actually affect custody cases. Traditionally speaking, women were stay-at-home moms, men were the breadwinners, and they brought the money home, which made it very easy to say that in a divorce case, dad would have every other weekend because dad still needs to make the money, and mom would be primary parent because that's what she has already done. That's no longer the case, really, and for a number of reasons. Sometimes women want to be in the workforce, and they're in the workforce for the entirety of their marriage, which means that once the marriage is dissolved, parenting time needs to allow for both parents to continue with the careers that they have built. And so whatever the shared responsibilities were during the marriage is also going to be the shared responsibilities post-marriage. Custody now looks to accommodate a woman's work schedule. So if a man has to maybe take a step back in terms of his career path because he needs to take on more responsibility with the children so that the mother can go and support herself and build up a career and a life post-divorce and have that independence. Alimony is no longer something that she's going to be able to rely on forever. And so at some point she will need to be able to enter the workforce, and it is expected that the man is accommodating in terms of what that looks like. Like I said, alimony is no longer something that is given for life. It's typically between half to a quarter of the marriage. If the mom has been a stay-at-home mom for the entirety of the children's minority, then she's going to get more alimony because she's going to need more time to be able to get back into that workforce. But there is a finite date in which that ends, and so that is going to affect what custody looks like. Traditional social norms for parenting. How the earlier social norms do actually still impact custody to this day. Women are seen as more nurturing. If you're in a county like Fulton, you're going to have a very different outcome in terms of what the parent or what the courts look at and what the judges look at than you would in a more rural, traditional, maybe Bible Belt conservative sort of area where the judges and the people all adhere to more traditional norms. There is this idea, and I've heard many judges say this, that one home is best in that it creates routines and patterns and stability for the kids to have one primary place and then every other weekend going somewhere else. All of that being said, we are starting to see new social norms for parenting come forth, especially with younger generations. Our younger millennials, our Gen Zers are challenging that status quo. They're challenging that status quo for a number of reasons. You know, some of them have been in the workforce their entire life. Some of them come from homes that were separated themselves and they don't want that every other weekend for their children. They want equal time with both parents. And so now we're seeing a more active role in fathers wanting and seeking that parenting time. I have had cases where guardians have told me it's very rare that a dad wants the time. So since he wants it, I'm going to give it to him. And people are coming around to that idea that a father who wants to be active in a child's life should be active in a child's life. There, as I said earlier with the studies, there are studies showing that having access to both parents, you know, in equal or close to equal format is in the best interest of the children. And we're seeing that children are very resilient and that routines can be stabilized within two households so long as the parents are effective in co-parenting and communication. Now, this will only work in a case where you have a very amicable relationship between the two parents. They're wanting and willing to work together towards what is best for their children. And so it's completely a case-by-case basis, but we are seeing a trend move in a different direction. Georgia specifically has not gotten to this point where it is memorialized in law. States like Florida have. They recently passed a law that has the starting point for all parenting time at 50-50, and then you move the scale based on that for, you know, evidence. Whereas Georgia still very much so does the traditional primary and secondary parent unless either the parties agree or there is compelling evidence convinced to the otherwise. Exceptions to the joint physical custody or parenting time sort of schedule, the reasons why we would see a sole custody situation. If you have a situation where a parent has abandoned their child and they have no relationship with mom or dad because they left and haven't seen them in 5 years and they come back and they file to legitimate and have parenting time, well, they're not going to just automatically give some sort of joint physical custody schedule. They're not even going to give a every other weekend schedule. That parent is going to have to work towards building and establishing a relationship. Abuse, neglect, drug use. These are the classic defects sort of issues that you would see when it comes to child custody. If you have these sort of issues in place, you have a very compelling argument for sole custody, and the courts will hear it, they will consider it, and there's a high likelihood that you will prevail on those issues. Courts are not going to put children in danger ever. And then you have the long distance parenting plan. Long distance parenting plans come in play when you have a parent who relocates. Maybe they relocate for work. Maybe they relocate because the divorce was hard and now they have to rebuild their way of life and need to go near family for support. So a single parent who now needs their mom to be babysitter is going to go back to that place in order to get work, get support, and, you know, rebuild themselves. And that's going to allow for a long distance parenting plan. Sometimes it's dad who relocates across the country in order to take a great job opportunity, bring home more money, support the kids that way, increase child support, go across the country. Parenting plans are designed to allow for that, but that's not going to be obviously a traditional every other weekend sort of parenting plan. It's certainly not going to be a joint parenting plan where you have a week on, week off, because the logistics of it simply don't allow. Typical custody schedules in Georgia. We've talked about joint versus sole and final decision-making authority. So when we're talking about final decision-making authority, what we're looking at is 4 issues: education, medical, religious upbringing, and extracurricular activities. Either parent can have that final say. You can split it in any way you want, as long as somebody has the final say. A lot of times you'll see the primary parent take all 4. It just makes sense. In a long distance parenting plan, the parent that has the children will take all 4 because they're the ones that are physically there, picking the doctor, signing up for the extracurriculars, taking them to church on Sunday. And sometimes it doesn't really matter which parent gets what, because the children are older. You have a 16-year-old, they're already established in their extracurricular activities. Their doctors have long since been established. Their educational needs, they're in high school. That's not going to change any. And then religion, typically speaking, people who raise children together have made that decision. And by the time they're in high school, you know what that looks like. So physical custody. You've got joint physical custody. When you do joint physical custody, you can do it 1 of 2 ways. You can do it week on, week off, and then you can do 2-2-5-5. I personally, even as a guardian, can tell you I don't like the 2-2-5-5. It's very disruptive for the children, and they have to constantly keep track of which house they're in, why they're at that house, when they're at their house, what books they have to bring, because you're basically switching your Monday and Tuesday every other week. Your Monday, Tuesday, and Wednesday, Thursday flip every other week, and that's not fair to them. The week on, week off is more stabilizing, but it does deprive them of a parent for a full 7-day period, which means that if you're going to do that kind of plan, it has to be done in a way that allows for a lot of consistency. Because if you're not running your household the same way, by the time you get through your week with, parent A, and then you're at parent B's house and they do things completely different, it's halfway through the week before you're into the new routine. And then you finally get settled in that, and then you're back at parent A's house. And it only works if the parents are just absolutely on the same page when it comes to raising their kids. The other option is primary and secondary custodian. And this can be anything from every other weekend, Friday to Sunday, with maybe a dinner on the off weeks. That's the most restrictive traditional parenting plan that we have. You can do Friday to Sunday and then an overnight on the off weeks. And the most expansive that you can do without doing a 50-50 is it's a 60-40 on paper, but it comes down to 1 night a week in practice, if you actually count it out on a map or on a calendar. And what that is it's Thursday from the release of school until Monday morning at the start of school. And then on the weeks that you're not with the parent for the weekend, you have Thursday night to Friday morning. So if mom is primary, dad is secondary. Dad's got them from Thursday to Monday, and then on the off weeks, Thursday night to Friday morning. So the kids know they are always with dad on Thursday. Like, that is just set in stone and part of their calendar. And then every other weekend they have extended time. Personally, as a guardian, if you're going to try to do something close to a true 50-50, this is my favorite parenting plan because it does account for stability. Holidays and summer schedules. The holiday and summer schedule is going to be a basic flip. Even years, one parent will have certain holidays, and then odd years, the other parent will have certain holidays. And that is rotated. So if you've got Christmas, you won't have Thanksgiving. And if you have Thanksgiving, you won't have Christmas. And, mom has even years, dad has odd years. And you can split you can be as restrictive or as broad as you want in terms of that. You can do, just Christmas, spring break, fall break, the Mother's Day, Father's Day, and um, Memorial Day, Labor Day, or you can get into all of the holidays like President's Day, Veterans Day. Anytime the children have off school, you can rotate which parent has that. And you've got a lot of options in terms of what you want that to look like. Again, there are always special considerations that go with the general terms of how a custody battle is going to work. All things being even, it's going to be what we just talked about. But if there is substance abuse, long distance parenting, there's mental health, family violence, or other issues, you have the option of asking for supervised visitation. You can do step-up plans with substance abuse so that the parent who has the addiction is required to do drug screens or, blow into a breathalyzer. The parent who is concerned about the substance abuse can request these things before the parenting time if they think that the parent is using. And basically what you do is you create a restrictive parenting plan that says, daytime visitation for 6 months until the parent shows that they've done their sobriety and they're working their plan. And then the next step would be like one overnight and then eventually every other weekend with a reversion back to phase one if they relapse. And that way it gives the parent with the substance abuse issue something to work towards while simultaneously allowing for protections if they can't do it. It's been my experience through both my career in dependency and in family law, if the parent is not truly on their path for sobriety and they have not worked the plan, they're not doing it themselves, they're not doing it for their own reasons, they're never going to get out of phase one. It's not going to happen. They're going to remain in phase one for the duration of their children's minority. The children are going to be protected. But they're also not going to lose hope, and the courts they're in essence basically sole custody, even though on paper they've given something to give the ability to try. And then if after 2 years they're not able to do it, you can always file a modification to have that revisited and say, well, they had 2 years and they never got out of phase one. Can we go ahead and just do sole custody? And typically speaking, at that point, you have enough evidence to go ahead and take that next step. Long distance parenting plans, if a parent relocates, they're going to be able to maximize time over the breaks, which means they're going to have less time during the school year. Instead of it being an every other weekend, they're going to have 1 weekend a month where they have to travel to see the kids, and then they'll have half the summer to be able to make up that lost time. If the parties can't agree, how does Georgia decide? The statute that we use is OCGA 1993. There's no presumption in Georgia for any form of custody, which means we don't have a starting point of 50-50. We don't really have a starting point of every other weekend. It's completely done based on the best interest of the child and what promotes their welfare, with the understanding that you're going to go through an entire process, including mediation, where all of these things hopefully will be negotiated out. That's what's best for the kids. If you're not able to do that, then it'll be determined by a judge in a court. The other thing is you always have the option of a guardian ad litem or a custody evaluator. It's a third party that comes in and looks at all of the issues, the facts, does the interviews, talks to the kids, talks to the school, talks to the parents, and makes a determination on what they think is best for the children, and then gives that recommendation to the court. Judges rely very heavily on what the guardian thinks. So when you pull a guardian in, expect what they have determined to be what's best for the children to be what the judge is probably going to do. And I would say 90 to 99% of the cases. Specific factors that a judge can consider. The judge is going to look at the relationship between the child and each of his parents, their siblings, step siblings, half siblings. I think that a lot of people don't realize that sibling relationships are actually put in higher weight than relationships between parent and child because sibling bonds are so strong and they're so important, which means that if you have a case where the one sibling is an affidavit of an election because they're over the age of 14 and can make a decision, the younger sibling will attach to that. They will not separate the siblings. In very few circumstances will they separate a sibling. Parenting abilities, they're going to look at what each parent has the ability to do and how they have contributed during the course of the marriage from raising these kids. Each parent's ability to provide food, shelter, taking child support into account. So, that does count, towards like, are you able to support your children? But home environments, continuity for the child, each parent support system. Is your family nearby? Is his family nearby? Mental and physical health of each of the parents, involvement in children's activities, which parent is showing up every weekend, which parent is going to PTA meetings, which parent is doing the IEPs, doctor's appointments, employment schedules, any special needs of the children, the willingness and ability of the parent to facilitate and encourage a close relationship with the other parent and their siblings. So the court does consider, is a parent engaging in parental alienation? Are they trying to create a situation where the child will not go to that other parent? Mm-hmm. And if the court will say, we're not going to allow you to have that additional time with the child because of that. The Galler custody evaluators recommendations has to be behavior and parental substance abuse. This isn't an entirely inclusive list, but it's the high point of what the courts look at and certainly what guardians look at. A special note is that when a child turns 14, they do have the ability to sign an affidavit of election, which means they get to sign a document that says, Judge, I want to live with mom or I want to live with dad. And here is why. And once the child does that, the burden shifts. There is a presumption that a 14-year-old knows what they want and that they have good reasons for what they want. And so instead of it being on, the parents to talk among themselves as to what is in the best interest of the child, it becomes the burden of the parent who wants that affidavit overturned to say why their child does not know what is in their own best interest. This is honestly why I try not to involve children, because at that point you are asking a parent to tell a child that they don't know what is best for them, and that is going to may cause irreparable harm in their relationship because you have now just stifled the voice of your own child. And you've also asked your child to choose between two parents. So in that situation, both parents, I think, are kind of in the wrong. But it is something that you can do, and it is an option that is available. And courts do take them very seriously, and they take them at their word. What we see courts focus on when it comes to child custody cases. Courts do not like bad-mouthing of parents. They do not like parental alienation. They take that very seriously. They absolutely look at the involvement of each parent. If mom has been the one who has done all of the education, all of the medical appointments, all of the extracurricular activities, they sign them up for everything, they go to practice, they are there every single Saturday with those orange peels for the kids ready to go after the goal is scored. That all goes into what a court is looking at. And a court does weigh that very heavily. The court's going to look at the relationship of the child with each parent, how the parents are attentive to a child's needs, proper and stable housing. And that doesn't mean who has more money. That means who is providing a good environment for their children to be raised in. which provides a home where the children feel safe and secure. Work, travel, long hours, a parent that is going to constantly have their child in childcare because of their incredibly busy work schedule the court is not going to give them more parenting time so that the child can sit in childcare. They're going to make sure that the children are completing their homework in both of their homes, and they're going to look at the distance between the homes and the school. So when a divorce when you're going through the process, if one parent moves out of the school district, well, that is going to affect their ability to get primary custody, because you're now going to have to remove the children from the school, or you're going to have the child having to drive, over an hour to get to school in the morning, because, dad moved out of county and now he has them 50% of the time. The court's probably not going to do that. The court's going to say, you're not close enough for that to be realistic for the children. What the courts do not focus on, they don't focus on diet. If you're feeding your kids fast food or junk food, if you're the one that, on the way home treats the kids to ice cream because they got an A on their progress report, the court's not going to listen to one parent badgering the other parent about that. Clothing, ill-fitting clothes, holes, weather inappropriate. It's not really going to come into play, especially if income is involved. If they can't afford to buy new clothes, like, the court's not going to punish somebody for that. Items not coming back. This is a big one. When you transfer the kids between the two homes, sometimes they bring their stuff with them. If a parent doesn't send the stuff back, the court is not going to say, well, that's a reason to modify custody. Relatives, like, they're not going to say, well, he spent the weekend with grandma instead of dad. That's okay. Kids get to see their relatives. They get to see their cousins. They get to see their grandmas, their grandpas, their aunts, their uncles. One parent's dislike of the relatives is, unless there's, substance abuse or some sort of physical or sexual harm that could come to the children because of a record with that parent, with that relative, it's not going to come into play. The fact that, you don't get along with your mother-in-law anymore, your husband doesn't get along with his mother-in-law anymore, is not going to affect parenting time at all. New girlfriends or boyfriends, this can be a tough one because as time goes on, people do move on. There are clauses that are put in place that say you have to introduce the other parent to the partner before you introduce the kids. But the fact that they have a boyfriend or a girlfriend is not going to affect parenting time. Of course, that does go into the same of just like relatives, all things being equal. If they have some sort of criminal record, that does create an issue that would be modifiable. Infidelity. Being a bad partner does not necessarily make you a bad parent in the eyes of the law. So the fact that one spouse stepped out of the marriage is not going to come into play when it comes to parenting time. Parents' hobbies, pastimes, what they do when the kids aren't with them also does not come into play. Having your kids on the TV or the phone or the Xbox way too much also come into play that much. Grooming issues isn't going to come into play. Mental health and substance abuse is not going to come into play if they've rehabilitated. So if, for example, that step-up plan that I talked about earlier, if your ex works the plan and they have made it from phase 1 to phase 3 and they are doing great with the kids, what happened at the time of the divorce will not come back into play. The way I always frame it to my clients is every single time a final degree is entered, it is a fresh start. So when we're talking about modifications or changes in the future, we are starting from the date of that final degree moving forward. We do not rehash things that happened 20 years ago. And that's a really good way of looking at it, is when the final degree is entered in any divorce or modification, anything moving forward is going to be a fresh start. And the same goes to old criminal convictions. They got in trouble when they were 20. That's not going to come into play, especially if it's unrelated to child safety issues and they're now 40 years old. I think the last thing to really focus on is what can be unrealistic expectations when it comes to parenting time. And it's hard as a parent to kind of accept this as the new normal, but it's not something that a court is ever going to grant. So I always tell people in mediation, you can get your spouse or your partner to agree to it voluntarily, all the better. Put it in a contract because then it is binding. But you do not take this to a judge because a judge will never order it. You're never going to get an unequal split of holidays and breaks. One parent is not going to get every single Christmas. You're not going to get a restriction on travel. If one parent wants to take their children on vacation during their summer break to see Old Faithful, they're going to be able to do that. You're not going to be able to move out of state with the kids and then not give up extra breaks in a long distance parenting plan. The parent that moves is going to, especially if they move with the kids, is going to have to make up that time to the other parent because they are the ones who voluntarily relocated. You have to keep each other informed. Like parents have to talk and have good faith conversations. Now, the good faith conversation can be as simple as, I want to enroll Johnny in soccer. Why not? No, why not? Well, Johnny told me he wants to play baseball. Maybe you go back to Johnny and say, do you want to play baseball? Or you say, you know what? I know Johnny really wants to play soccer, so I'm going to have Johnny play soccer. You just take each other's opinions into consideration when it comes to these things. And like that's really as simple as the conversation has to be, but it does have to be a conversation. There's never going to be parenting plans that don't allow for overnights on school nights. You're not going to have restrictions on phone calls and communication with the child. The forced communication with the child can be a little bit more difficult because there are cases where parental alienation has occurred, or sometimes there are cases where a parent acted incredibly bad towards their child and they personally damaged their relationship with their child, and that parent has to mend that crack, that fault. And if that happens, you're not going to force communication. Like you're going to have that the parent that caused the break is going to have to do therapy with child to rebuild that bond. Court's not going to order otherwise on that, I don't think. Restrictions on moving school districts. Sometimes parents have to move. Like it's just a fact of life, jobs, that happens. Third party final decision making. Girlfriends, boyfriends, stepdad, stepmom is not going to be making decisions for the kids. It is mom and dad only. Don't expect a judge to hear every single detail of your case and every single bad thing that has happened throughout the entirety of your marriage, with every boo-boo, cut, scrape on the kids from outside, because one, the judge does not have the time for it. Two, they don't have the patience for it. You want to curate your case if it's before a judge so that it does not water down the important things. If you and your attorney said, this is important enough, I'm taking it to a judge, I am not budging on this, you want to make sure that you make every single one of those moments count. And it is a very strategic thing, and it's very judge by judge. Make sure your attorney knows the judge and knows what they like. Because I can tell you from personal experience, up in a certain county that I've practiced in for years, there are 3 different judges on the bench, and there are 3 different Ashleighs that they get every single time I walk into that courtroom. Judge A is going to get a lot of drama. Judge B is going to get a settlement outside of the courtroom because I know he's not going to hear it, and he's going to make me sit there all day trying to settle it. And then Judge 3 is going to get the facts very plain and simple. And there's going to be no theatrics, no drama. He doesn't like it. And I always warn my clients ahead of time, like, this is the judge you drew. This is the Ashleigh you're going to get that day. So know your judge. That's very important. And then the last thing is, do not expect a quick process if you want a judge to decide. It can take a year to even get before a judge on a final in a divorce. And even within that year-long period, judges don't typically rule from the bench when it comes to kids. They're going to take the evidence, they're going to go back, they're going to think about it, they're going to read the case law, and they're really going to put some work into what it is that they think is in the best interest of the child. Because, at the end of the day, it has been my experience that these people do genuinely care. They care about the law, but they also care about the people and the children who are involved in it. Again, this is just kind of a final overview. When it comes to typical outcomes, you're looking at legal custody. There's going to be a final decision on those four things: medical, education, extracurricular, and religion. Someone's going to have final say. And you're either going to do a joint physical or you're going to do a primary and secondary physical. I would say about 80% of our cases settle in mediation. And so when you go into mediation, you typically have a good idea of what it is that you want that to look like. And a really good sound mediator is going to be able to come up with a plan that works for both of you. Depending on the case and depending on who the parties are, if you are a party that is, like my friend who they have a parenting plan, I don't think they've ever looked at it. They co-parent so together, and it is so seamless. I have never seen anything but like it. I would love to get them to run their own boot camp on how to effectively co-parent. You got cases like that where the parents they know what's best for their kids. At the end of the day, they just want what's best for their kids, and they're super amicable about it. And then you have cases where you may be dealing with a narcissist. And in those cases, do not expect to stick that parenting plan in a drawer and never look at it again. In those cases, you're going to have to be very detailed, very specific. You're going to have to think out every single eventuality and have it written in a way that is very clear and defined in its terms. You're also going to have to be very strong in sticking to it. You're not going to have the option of saying, oh, let's just switch weekends, it's fine. Because when you give an inch, they're going to take a mile. And that is, again, a completely case-by-case basis, and it depends on who it is that you're dealing with. But those are typically what I see as the two outcomes in any divorce. Right. Tips for a successful custody case. Carefully pick your attorney. Pick somebody who knows family law. I always say a jack of all trades, a master of none. Do not pick somebody who does everything because they don't know family law. They don't know it in and out. It is actually a very precise and curated area of law. Have realistic goals. Unless you fall into one of those very, very slim categories that I talked about, don't expect sole custody. Utilize a therapist early on. Having a therapist for yourself and your children is so important. And it helps with the process. It helps the children process and it helps you process. I always tell people that, if you broke your knee and you needed to go see an orthopedic, you would not hesitate to do it. So do not hesitate to fix the doctor that is equipped to fix the brain. That is all they are doing. Keep very detailed records, calendars, text messages, emails, report cards, any ring doorbells, voice recordings, journalist receipts, whatever it is that you can gather, save it. The only thing that I do recommend being careful on is recording the kids, because there are certain judges that do not like it when the kids are recorded. They look at that as, well, instead of pulling out your phone and recording the kids, you could have done something to help them. I just put that out there as a general warning. Some judges do take that into consideration. Always communicate in writing. Be a very involved parent. Never forfeit parenting time. If it is your time, don't say I don't want it. Don't badmouth the other parent or limit their parenting time or communication. That is the easiest way to file for modification is parental alienation. Minimize conflict with the other parent, and don't expose the kids. And when I say minimize contact, do not kowtow to them, but just use our family wizard or some sort of form of communication that can keep the conversations very precise. So if you are dealing with a narcissist, for example, you can say, this is what I want to do for Johnny. They respond, I don't want it because of X, Y, and Z. Thank you for your input. I have taken it into consideration, and this is what I'm going to do for Johnny. And that's it. Give them nowhere to go. And if they send a bunch of emails afterwards, your decision is made. You've had the good faith conversation. If you can afford it and you think it's necessary in your case, psychological custody evaluation or a GAL. It depends. Psychologicals are really good in cases where you are dealing with somebody who may be harmful to the children. A guardian ad litem, there are some guardian ad litems that I would absolutely take over a psychological custody evaluation. And then there are others that I would say, no way. So just if you do go the GAL route, make sure they're a reputable one. And your attorney should be able to tell you which ones have a good reputation and which ones are not worth talking to. Use your attorney to filter and edit communications with the guardian, with any evaluators, with the other parent. It's good practice and it creates good evidence. Obviously, be very, 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 very patient. Litigation is a slow process. And finally, the best thing you can do is make a real effort to reach a settlement, because ultimately, when you settle on your terms, even if you're compromising, you are deciding those compromises. The second you step to a courtroom, a judge is deciding those compromises for you.